My name is Paul Horn. I am a probate attorney. All I do is probate. Okay, I do probate, living trust. Okay, so what are we going to learn in this webinar is basically if a homeowner pass away, how will you sell their house? Okay, if a homeowner pass away, you're taking the listing, what will you do? Okay, so that is kind of where we're going with the next 2 hours. Okay, and the best way to learn is to ask questions. So if I'm going over some stuff and you don't quite get it, type it in the chat box. Okay, yeah. Okay, all right. So in your career, you're gonna come across someone who passed away, right? Because people still die, I think, right? Do homeowners still die, gang? Do they still die? If the answer is yes, people are still dying and they will die, right? So when homeowners do pass away, when you're talking to the son, talking to the daughter, how will you be able to help them, right? How are you going to take the listing? If you wanted to buy that house, how would you do it? Okay, so how does the paperwork flow? Right now, when you sell a house, the seller signs your paperwork, right? Right now, in a regular normal transaction, the seller signs your listing agreement, but this webinar is about your seller is in heaven. Your seller died. How do you go about doing that? Okay, all right. So look, the first thing you ought to do, the daughter comes here and says, hey, can you please sell my mom's house, my dad's house, my brother's house, my sister's house? He or she passed away. The first thing I'll do is pull up the grand deed. The first thing you got to say is, hey, your mom passed away. What is the address? What is the address that the house that she owns? You're going to pull up the grand deed. Okay, you're going to pull up the grand deed. And how do you pull up the grand deed? You do that by what? Calling your title company, I'm guessing, emailing your title company, right? Your title company will give you the grand deed. And the grand deed is going to tell you whether the house is in a trust or not. If the house is in a trust, no probate is needed. Okay. So if the house is in a trust, yay, you break out into a dance. Are you guys familiar with this guy who's dancing on the screen? Type in the chat box if you remember who this gentleman is. So if the house is in a trust, you're going to break out into a dance like, thank you, Ronald. Yeah, like Carsten. Yay, the house is in a trust. You don't need a probate. And you're going to see a lot of that. You're going to see a lot of that. A homeowner passed away, the house is in a trust. Wonderful, no probate needed, no court intervention needed. You can go forward with your listing. All right. So mom died. Mom has 4 children. Mom died. Mom has 4 children. Mom has a trust. Who's going to sign your listing agreement? Who among the 4 is going to sign your listing agreement? Well, it's going to be the successor trustee. The answer is D, successor trustee. Okay. Mom passed away. You pull out the grand deed. You confirm it is in a trust. The successor trustee signs your listing agreement. So how will you know who is the successor trustee? So it's in a trust. The successor trustee signed. Mom has 4 children. How will you know which of the 4 is the rightful person to sign your listing agreement? Type in the chat box. How will you know? Who would that individual be? Successor trustee, and you would find that name in the trust. You look through the living trust. You look through the binder to see who is the successor trustee. Okay, yeah. So let's use the word successor trustee. Okay. The technical term, successor trust. If the house is in the trust, the successor trustee has the ability to sign your listing agreement. Successor trustee. Okay, I want you to memorize that. I want you to memorize the phrase successor trustee. It's going to happen to you. A homeowner died. You're taking the listing. The house is in the trust. You need to find out who is the successor trustee. And you do that by getting a copy of the trust. Okay, help me out in the chat box. In the chat box, where will I get a copy of the trust, guys? Type in the chat box, help me out here. How would I find out, how would I get a copy of this trust? Where would I look to get a copy of the trust, guys? Any idea where would I get a copy of the trust? Okay, so Patricia says the county. So your trust is never with the county record. Melinda, title is not going to have it. Sean, the court's not going to have it. Okay. Someone says, hey, ask the lawyer. Oh, Mo say, ask the lawyer. So Mo, you call up the lawyer. The lawyer is dead. Sarah, the lawyer is dead. Man, what good is this lawyer? He's dead. Oh no. Lawyer died. Can you believe that? The lawyer who did his trust is dead. Oh my God. When he did my trust, he never told me he was going to die. The lawyer is dead. The family, that's right. Yeah, ask the family. Ask the family for a copy of the trust. Okay. Ask the family for a copy of the trust. And they're probably going to show you. They're probably going to show you it's probably in a binder. It'll probably in a binder like that, what you see on the screen. Okay. Yeah. So the easiest, simplest way is ask the children for a copy. Okay. Yeah. Ask the children for a copy. So when mom passed away, mom and dad die, right? So when mom and dad, have the children look through the house for that binder. When mom and dad die, have the children look, if they don't have a copy, have them look through the house for that binder. Okay. Yeah. Tina says, I thought the lawyer was the main source. Tina, I have news for you. Lawyer died. Tina, are you really gonna depend on the lawyer? Lawyer died. Did you know that? The lawyer died too, just like you. Right. So take, matter into your own hand. Make sure you have a digital copy of your trust, right? Because that is a legal document that says, when I die, who has the power to sign my trust? Now, what happened if you're unable to find this binder? What happened if you're unable to locate the trust, guys? What happened if you cannot find a copy of the trust? Can't find it. Mom died, the house is in the trust. You just cannot find a copy of the trust. What happened? And I think Sean's got it right there. SOL, if you lost a copy of a trust, it goes to probate. Okay. If you cannot find a copy of a trust, it's going to go to probate. Okay. Understand, guys, understand that your trust, this binder is a private document. No one has it except the family. Okay. No one has it except the family. Okay. So, what I recommend is always get a electronic copy. Okay. So when you go get your trust, the lawyer will give you a binder like that, what you see on the screen. And also you get a electronic copy, a small little USB like that. Okay. All right. Okay. Let's take a look at what is the essential component of a good estate planning. So we talked about when mom died, the house is in a trust, the successor trustee has the power to sign your trust, your listing agreement. Okay. So so I'm gonna give you 7 things that are important in a trust binder. in your estate planning. One is the actual trust. The other one is the durable power of attorney. Let's talk about the durable power of attorney. Any of you out there know of someone who has dementia or Alzheimer's? Type in the chat box for me. Do you know someone who has dementia or Alzheimer's? Yeah, Sandra. So that person, let's say that person you know has dementia. Let's say that person is the husband, and the wife and the husband comes together and says, hey, can you please, Sandra, can you please list our house? Can you please sell our house for us? Sandra says, yeah, I can sell your house for you. I'm a realtor. Great. Wife, Miss Wife, she signs your listing agreement. The husband has dementia, Sandra. Can the husband sign your listing agreement, Sandra? Husband and wife is fine, husband's dementia. Can husband sign your listing agreement? The answer is no. So what will you do, Sandra? What will you do? You ask them for the power of attorney, right? So in this binder should be a power of attorney. And the power of attorney is going to say, hey, if I am ever incapacitated, my wife will be able to sign my listing agreement, okay? Or my husband. So normally when a couple goes and have their estate planning done, of course, it's the trust. The trust is going to say, hey, when I die, Mary, the oldest daughter, is the successor trustee. She's going to sell the house, sign this agreement, divide by 4. In that binder also is the durable power of attorney. The durable power of attorney says that if I am incapacitated, the phrase is incapacitated. Incapacitated covers dementia, covers Alzheimer's, covers when you're in a coma. That's incapacity, okay? The phrase is incapacity. All right. So a durable power of attorney is very, very important, okay? The durable power of attorney says, if the husband is incapacitated, the wife can sign your listing agreement. That document comes from the durable power of attorney. If you don't have a durable power of attorney and husband and that couple needs to sell that house, then they have to go to the probate court under something called a conservatorship, okay? All right. And then in your estate planning binder, you ought to have an advanced healthcare directive. You ought to have a pour-over will, What is a pour-over will? So how many of you have refinanced your house? Can you type in the chat box for me that you have refinanced your house? You have a trust and you refinance your house. Okay. A lot of time you have a trust, the house is in the trust. When you refinance it, the lender took it out of the trust. Okay. The house is in your trust. When you refinance the house, the lender took it out of the trust to refinance the house. And now you pass away. What happens then, guys? You had a trust. The house was in the trust. You refinanced it, the house fell out of the trust, and you pass away. If that were to happen, guys, if you have a pour-over will, that basically, like you see on the screen, it pours everything back into your trust. So if an asset, a house is not in your trust, the pour-over will pours it back into the trust and you can avoid a probate, okay? That's known as the Hexstead petition, okay? That's known as the Hexstead petition. So that's why when you do your estate planning, you got to have the trust. You got to have the durable power of attorney. You got to have the advanced healthcare directive. You got to have a pour-over will. So these are all very critical components of what makes a good estate planning to avoid a probate, okay? Trust transfer deed. So when you go get your trust done, the lawyer will draft a brand new grantee showing that your trust owns this house of yours, okay? And personal property, jewelry, car goes into the trust as well. If you have an LLC or an S corp, that goes into the trust as well. Okay. What I'm going to do is this. I'm going to share with you. Oh, let me see. I'm going to share with you a terrific. Let me see. I'm going to share with you a terrific video. So on your own. Let me see here. So far in the first 20 minutes, I've covered what makes a good trust. What you ought to do is this. If you wanted to have a checklist of what makes up a good trust, this would be the first link I'm going to give you. This is the first link I'm going to give you. It's about a 20-minute video that goes over everything again, what I just talked about. Okay. So when you click on that link, it will take you to my website where I explain to you everything I just talked about. What makes a good living trust? What is a durable power of attorney? What is a pourable will? Okay. So you can do that on your own later. All right. Let's see here. Let me take some. Let me see here. Yeah, so Nan asked a question, if you have a trust, is it necessary to record it with the county recorder? So the answer is no. The answer is no. A trust is not recorded at the county recorder. It's not. Your grand deed is recorded with a county recorder, but not a trust. Not a trust. Okay. Let's see here. Cassie, thank you. you couldn't see me. Now you can see me. Hi guys. Sorry about that. But okay, great. So I was looking at one of the questions that came from Nan Free says, hey, should you record it with a county recorder? If a trust, answers no. A trust is never recorded. Hi, Matt. Okay, yeah. So before I move away from trust, before I move away from how to handle a homeowner who passed away, the house is in a trust. Before I move away from that topic, are there any questions before I move on? Okay, so C. Woodgard asks, how do you prove validity of a trust? So meaning here, let me say hi to C. Woodard. Let me see if I can, let me see what he means. Like mom died and some shady person or some shady daughter is coming up with a trust. Let me see what he's asking me. Hi, C.
Hi, how are you?
I'm good. Yeah. What is your question, C?
I'm as you were leading into, what happens if, whether it be family members or someone not related, decides they want to contest the validity of the trust?
See, you can sue me because in the past 23 minutes, my tone of voice sometimes sounds kind of rude to you. You can contest and sue me, doesn't mean you're gonna win, see, you know?
Makes sense. You can sue anything, but
right. But
all right. So then they would probably have to hire someone to
see.
I don't know. How do you prove the validity of it?
See, that person comes on board and says that trust is not the real trust. See, you tell me, why is it not the real trust? She is my mom. He is my dad. He has 3 children. We're all here. That's our dad. The house is to be given all 3 of us. Sir, Mr. C, tell me again, why do you think this trust is no good? Tell me again, C. What's your proof? The burden is on you, sir, to prove it, right?
Okay.
Do you have another trustee that gives the house to you? You see, you got to come to the table with some evidence why this trust is no good. See, are you there?
I am. That's good. That's
Yeah,
good. Yeah. The burden of proof is on them.
right. And Canada makes a good point too. It is notarized. That's true too. Just like a grandee gets notarized. Yeah, so I wouldn't worry about that too much. I mean, it's they would have to prove that, look, that's not the handwriting. They would have to prove, that yeah, it has to be a lot more factual. So I wouldn't worry about that too much. I wouldn't worry about that too much. Your client died, pull the grandee. If the house is in the trust normally name one daughter, one son as a successor trustee, and then that individual can sign your listing agreement, Steve. And that's that. Okay.
All right. Thank you.
Yeah. And see, your question may has to do with a Jerry Springer family. And if you do have a Jerry Springer family, God bless you. Have a glass of wine and enjoy the stress. All right. Yeah. Yeah. And let's see. Olina says, is the trust still be valid if done without an attorney? Participation in California, just notarize? Yeah. So a trust does not need to be done by an attorney. It should be done by an attorney. Doing a trust on your own is the equivalent of, can I sell my house on my own, even though I never had a transaction before? I'm not a realtor. Should I sell the house on my own? So that's a similar analogy. Yeah. So when you go draft your trust, the trust is going to say Sandra Diaz Family Trust, dated August the 12th, 2022. That's the date you sign it. That's going to be the name of the trust. So Sandra Diaz, for example, goes and draft her trust. The name of her trust is going to be Sandra Diaz Family Trust, dated August 12th, 2022, assuming that's the date she signs the trust. Yeah. Okay. All right. Any other question? Let's see here. Any question before I move forwards? Yeah. So a trust is never recorded. You don't need it to be recorded. It's a private document. Yeah, it's a private document. It's not recorded. Okay. Yeah. So Tina says, so once I have a listing from the successor trustee, do I proceed the paperwork with you? So if the house is in a trust, the successor trustee signs the paperwork. You don't need to go see any lawyer. There's no court involvement. Okay. Yeah. There's no court involvement. So the question is, could someone fake a trust in order to fraudulently steal a property? Could someone forge a grandee? Could someone forge a grandee? Right? Could someone forge your check and take all the money out of your bank? So yeah. So I mean, it's I do a lot of trust. I do a lot of probate. I wouldn't worry too much about someone, you, regardless, KT, regardless, you need a trust. The only person that does not need a trust, the only homeowner who does not need a trust, is when that homeowner is never going to die. So that's the system we're in. If you own a house and you want to avoid probate, you got to have a trust. Okay. Yeah. So mom died. Mom has 4 children. Mom named one of the child to be the successor trustee. Can that one child buy the house? Buy that house? Of course, as long as he or she is buying it at the fair market value. Okay, buying at the fair market value. Okay. All right. Let me see here. I think there is let's see. The next question is, if the trust names all heirs as equal to inherit the property, who needs to? Okay, so Nanfree asked me a question. So Nanfree, you're missing the point. So Nanfree is saying, hey, if the trust names all heirs as equal to inherit the property, who needs to sign this agreement? The only person that signs the list agreement is the successor trustee. Okay, the successor trustee. Okay. All right. Let us move on. Let us move on. Okay, so let's do joint tenant real fast. Let's just do joint tenant real fast. First of all, you can all see my screen, right? The PowerPoint, right? Type in the chat box for me. Can you all see my PowerPoint? Okay, let's touch base on joint tenant, okay, because it's important. Joint tenant. Let's start off with joint tenant is last one surviving takes it all. So who of you here bought a house with someone else in joint tenant? Can you type in the chat box to me who you bought a house in joint tenant with someone else? Okay, yeah, so in joint tenant, if you die, the survivor takes it all. Okay. So so for those of you who bought a house in joint tenant, if you die, the survivor takes it all. So you say, well, that's no problem. I bought the house with my husband. If I die, he takes it. Yay, fine, right? All right. So let's just flush that out. Let's just take it a step further. Let's say, for example, let's see here. Let's say, as an example, let's say Jane is 80 years old. She's a realtor. She's super rich. She's a realtor and investor. She's super rich, has a daughter from a prior marriage. And let's say Jane is going to buy a $5 million mansion and joint tenant with her new husband. Her new husband's name is Rico Suave. So 80-year-old Jane, if she were to pass away, Rico Suave takes it all because the house is under joint tenant. The daughter wouldn't get anything. So be careful with joint tenant. Last one standing takes it all. Okay. Last one standing takes it all under joint tenant. So when you buy a house under joint tenant, just be careful. Okay. And joint tenant also has a very adverse effect when it comes to taxes as well. So for example, if you bought a house in a joint tenant, a married couple can buy a house and vest it in 3 different ways. Okay. They can vest it as joint tenant, community property, or as community property right of survivorship. Okay. Let's see here. Let's see, let me make sure you can see the PowerPoint. So a married individual is able to buy the house as joint tenant, community property, and community property right of survivorship. If you are married, you should not take title as joint tenant because upon the death of one spouse, the surviving spouse only gets a half step up in basis. So if you look at this screen, joint tenant, let's say this husband and wife bought this house for $100,000 40 years ago. 40 years later, husband died. The house was $1 million when husband died. The wife sells the house for $1 million. Her capital gain is $450,000. Okay. But if she had it under community property, 100% step up in basis, no capital gain. Same thing with community property with right of survivorship. Okay. All right. So if you have a trust, put it inside your trust and label it as community property. If you don't have a trust yet, you're buying a house with you and your husband, which one should you choose? Well, if you want the best tax advantage, don't choose joint tenant. Then you're left with either community property or community property right of survivorship. Which one should you choose? Which one should you choose? Well, if you choose community property, if you choose the middle column, community property, you have to watch out for the pool boy. Okay, watch out for the pool boy, because the wife, if it's under community property, the wife can write a will and will her half to the pool boy because he cleans the pool so well. Okay, if it's community property, each spouse has the right to will his or her half away. But if it's under community property, right of survivorship, neither party can will their half away. So just, this is a very nifty chart to remember the difference between joint tenant, community property versus community property with right of survivorship. Okay. Now, I'm going to give you another video to watch. If your client ever have a question about vesting, let's say, for example, they're buying a house and escrow gave them paperwork and they're not sure, should they go joint tenant? Should they do community property right of survivorship? Should they do community property, tenants in common? Have them watch this video right here. What I'm going to do is this. I'm going to cut and paste this link. I'm going to put it into the chat box. So this will be our second link. So this is a vesting video. This is a vesting video. Okay. So if you have a buyer, your client asking question about how to vest title, that's a good link to send them to. That's a good link to send them to. Okay. All right. Let's see here. Someone raised their hand. Let's see who raised their hand. Hi, Lee. How are you? Hi. Did you have a question, Suk Lee? Did you want to ask me a question?
No, I'm sorry. It was when you ask something about previous question, raise your hand. That's what I raised instead.
Okay.
Sorry.
All right. Okay, that's fine. Thank you. Let me see, Blair. Hi, Blair. Do you have a question for me, Blair? Blair Dixon? Did you have a question for me or no? No? Okay. Blair, are you able to speak or no? I had you. Canna, you have a question for me?
Yes, I do. So if the property, like a wife and husband got the property in and the vesting type is joint tenancy with the right of survivorship, then father died. I mean, the husband died. Then as long as the wife doesn't sell, just inherit the whole thing, and then she can put it in the
Stop. The house under joint tenant, husband and wife, husband died. How do we get the house to the wife's names only? Let's start with that. So you and your husband, you bought into a joint tenant, your husband died. How do we remove his name from the house to give it all to you? That's question number one.
Okay.
How do you do that? You do that by getting his death certificate and file an affidavit of death of a joint tenant with a county assessor. Now you own the house by yourself. Now you can take that house, you can sell it, or if you're not going to say want to live in it, you can put that house into a trust.
Yeah. Okay, so if you sell it before you put it in a trust, then you're gonna get taxed for the capital gain of your house.
Yes. Yes.
Okay, so you'd better put it in a trust before you sell it, if you're a surviving wife.
Well, so when you buy a house from here on out, husband and wife, do it under column number 3, community property or right of survivorship.
Yeah, but the father, I mean, the husband already died.
Well,
and then it is a joint tenancy.
Yeah.
I mean, I have a client who's like that.
Yeah. Too late, too bad, so sad.
Ooh.
But let's say, Canna, and the next step, let's say she's not going to sell it.
Yeah.
Husband dies, she's not going to sell it. So she files an affidavit after the death of a joint tenant. What do you think? She doesn't want to sell it. What do you think she should do?
Affidavit of death, whatever it takes, and she should put it in a trust.
There you go. Why do you think she should put it into a trust? Why?
So that number one,
Because she's gonna die one day, right?
yes, right. And then
And when
her
she
kids are
dies,
not gonna be, yeah.
when
Mhm.
she dies in the trust, then her kid does not need to go to probate.
Right, exactly.
So to drive the point home, if you have a house, you should have a trust. You don't need a trust if you're not going to die. So your client don't need a trust if she's not going to die.
Okay, yeah, she's gonna need a trust for sure, but they're debating if they should sell it or not. So, I mean, she should sell it or not. So at this
Yeah,
point,
yeah. So that's a question for a CPA, you know? Yeah,
okay, thanks.
yeah. Okay, let's see here. Let me see if I can say hi to Christine. Let me see if I can say hi to Christine. She has a question. Hi, Christine.
Hi, how are you?
Good. How about yourself?
Good.
So your question is, can joint tenancy be switched to community property with right of survivorship? So the answer is yes. But the better answer is have them create a trust. And when they do create a trust, they can label that house in the trust as community property.
Oh, okay.
Yeah. Mm-hmm.
And
Yeah, so that when one spouse passed away, that house, because it's community property, if that surviving spouse decides to sell it, there is no capital gain because when it's community property, the surviving spouse gets 100% step up in basis.
and that's only for married.
That's only for a married couple. That leads me to the next question. Patricia says, if they are not married and only partner in paper, how would they choose vesting? Let me go to Patricia. Christina, did I answer your question?
Yep, thank you.
Okay, let me say hi to Patricia. I'm not too sure exactly what's her question. Hi, Patricia.
How are you?
I'm good. Okay, so they're not married, right?
They're not married, so this is friends, and they purchased the property together.
They're not married, they're friends. They're friends with benefits, Patricia.
Yeah, let's put it that way.
Okay. So if they're friends with benefit, they cannot do community property. Community property is reserved specifically for married individual.
Okay. So in this case, if something happens to either or, how would they do they have to go to probate?
So both names are on the house or just one?
Both names are on title.
Okay, and it's part of the joint tenant, right?
Yes.
Yeah, so if one died, then the other one gets it all.
Okay.
Patricia, hang on a second.
All right.
Hang on a second. Imagine this, Patricia. You, just as an example, you have two daughters from a prior marriage. You let's say you met someone, right? Or even marry someone. You marry someone, his name is Henry. You bought a house under joint tenant. Henry has two sons from a prior marriage. Okay.
Mm-hmm.
So the house under joint tenant. You have two daughters from a prior marriage. Henry, your new husband, has two sons from a prior marriage. The house under joint tenant. Mary, if you die, that house goes to your husband. When your husband dies, that house goes to his children only, Patricia, none to your daughter.
Okay.
So let that sink through. Joint tenant can really lead to a situation where it's heartbreaking. You marry Henry, it's a terrific marriage. It's just that the house is under joint tenant. You have two daughters, he has two sons. You die, the house goes to him. When he died, all goes to his children. How would you feel in heaven, Patricia, about that situation?
Not happy.
Yeah, exactly. Your daughter gets nothing. Oh my God. Too bad. So sad because it's vested incorrectly. Okay.
Okay,
All right. So just be careful with vesting.
okay,
Yeah. Yeah.
thank you.
Yeah. So Julie says, when would it be best to take title as joint tenant? When would it be best? When it would be best? Julie, I don't know when it would be best. I cannot find a reason when it would be best. You would have to give me a situation, Julie. Let's say, for example, you bought a house with your boyfriend, and if you die, he gets it all. Okay, joint tenant, you know. The best way is if you own a house, you ought to do it under a trust, own it by a trust. The trust would say, Julie, the trust would say, hey, if I die, my half goes to my sister, my daughter, my son, my mom, okay? His half, Julie, he'll say when he die, it'll go to his son, his daughter, or his mom, okay? Yeah. So a trust is a much better way to dictate who gets the property once the owner passed away, okay? So let's talk about tenant in common. Jose says, hey, but what about tenant in common? Jose, you bought a house with your sister as tenant in common. Let's say you bought, Jose, you're buying a house with your sister, you can do tenant in common. And then when you die, your half goes to your children, okay? But it's gonna have to go through probate, okay? Yeah. Okay, all right, let me, these are good questions. Thank you for asking, these are good questions. Let me move
Oh.
on. Yeah.
Just a quick question. I'm Patricia again. So going back into just quickly.
Sure.
So you gave me an example with if the person were married, but I gave you the example of if these people are partners and they're not married, so it's better to do a joint tenant. So again, the male.
No. When you say partner, what does that mean? Like in a romantic partner or just purely business partner?
Purely business partner.
Patricia, stop. You and I are partner, business partner. And if we do joint tenant, if you die, I get the whole property all by myself.
Even though the other person has children?
Too bad, so sad. You chose joint tenant. Last one standing takes it all. Yes.
Okay, perfect. You answered my question. Thank you.
Yeah.
All right.
Patricia and everybody online, do you understand why you gotta take a second look at joint tenant? If you're vesting your house under joint tenant, take a look. Why are you doing under joint tenant? Okay. I'm not beating down joint tenant. I'm just saying that under joint tenant, last one takes it all. Like Patricia and I, we're business partner. She has her own family. She puts in $1 million to buy this house. I put in $1 million to buy this house. She died. I take the whole shebang. Patricia's rolling in her grave in heaven saying, what the hell, Paul Horn? Give some to my family. Right, Patricia?
Right.
And I say, too bad, so sad. We're joint tenant. Last one standing takes it all. Okay.
Unless I marry the person and then I can do community property.
Yeah, but your business partner, do it under tenant in common. And then you do a trust and you remove your half into your trust. Your trust says, when I die, my half goes to my children, Patricia.
Okay, tenant in common. Got it.
Yeah. So if you vest it in a tenant in common with your business partner, which is the right thing to do, is a business partner, you buy a tenant in common, and you put your half into your trust. Protect your half. If you die, it goes to your family. Okay.
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 Thank you.
Yeah. Okay, let us move on. I want to touch on the step-up basis for 1 second. let's say, guys, let's say mom owned a house that she bought 30 years ago for 300,000. She died in 2021 and the house was 3 million. You are going to sell it for 3 million. So she only bought it for 300,000. And when she dies worth 3 million, you're going to sell it for 3 million. Are there any capital gain? The answer is no, because of the step up in basis. Remember this concept, step up in basis. Mom and dad bought it for a very cheap price. When mom and dad die and you sell the house for an enormous amount, like because the house is worth so much more now, there's no tax in between. That's called a step up basis. But to get this step up basis, you cannot put your children's name on the grand deed. You cannot do that. How many people do you know that's put their children's name on the grand deed on their house? Don't do that. It's a bad way to handle it. Okay. Your mom, don't add your children onto your house, because if you do that, it destroys the step up basis. They don't get the step up basis. Okay. So don't do that. Okay. So very important concept. If you want your children not to pay any taxes when they sell the house, simple concept, put into the trust. When you die, there's no probate, no probate. Also, when your children sells this house, there's no capital gain because of the step up in basis. Okay. Oh, let's see here. All right, let's talk about a probate. Okay, let's talk about a probate. So you only need a probate if the house is worth more than 184,500. Okay. So you only need a probate if the house is worth more than 184,500. Okay. Type in the chat box for me. How many of you or your client where the house is only owned by the husband or owned by the wife? They're married. It's a happy marriage, terrific marriage. Type in the chat box for me. How many of you where your client? Okay, so like only the husband owns the house. Okay, so Andy, so let's say the house is under the husband's name only. So it's a beautiful marriage, happy family, but because the husband has better credit, or the wife, so the husband has better credit, so the house under the husband's name only. Husband die. How does the house goes to the wife? Any idea, guy? They are married, but only one name is on the house, on the grand deed. So how does the house goes to the wife? There's no trust. There's only one grand deed and husband's name is on it. Okay. There is no will, no trust. How does the house goes to the wife? They've been married for 40 years. They bought the house 30 years ago. And for some bizarre reason, maybe he has better credit. We don't know what the reason is, but it's under his name only. He died. How did we move the house to her name? Okay. We can do something called a spousal petition, like we see in front of you. This is a very powerful way to escape a probate. If the house was bought during marriage and it's community property, you can avoid a probate by doing a spousal petition. So keep this in mind. A happily married couple and only one name is on the house, whether it be the husband or the wife. Okay. We can do a spousal petition and get the house to the wife or to the husband. Okay. So keep this exception in mind. It's known as the spousal petition. Okay. When we and the advantage of a spousal petition over a probate is that it's cheaper and it's much faster. As you can see on the screen, a probate would take like, 1 year to do. A probate takes 1 year to do. A spousal petition takes way less time, 3-4 months. Okay. Okay. All right. Let's So let's see here. Let's see here. Let us go back to here. So remember the spousal petition exception. All right. So mom died. You pull up the grand deed. The house under her name. She does not have a trust. And if the house is worth more than 184,500, then you need a probate. Are there any houses in California that's worth less than 184,000? Are there any houses in California? Very rare, right? So if you own a house, yeah, even Laguna Wood in the co-op area, maybe, you know, but if you own a house in California and the homeowner died, most likely it's going to go to probate because of that number, 184,500. Okay, so that is the magical threshold. A homeowner died, you pull up the grand deed, there is no trust, there's no trust, and the house is worth more than 184,500, you're going to need a probate. Okay, you're going to need a probate. Oh, let's see here. All right. So look at this chart here. This is a pyramid of who can be in charge of the probate. So let me give you a scenario and you tell me the answer. Let me give you a scenario. You tell me the answer. Dad is 80 years old. Dad is 80 years old. Dad married a 35-year-old wife. Dad is 80 years old. Dad has 4 children from the past. His new wife is only 35. Dad passed away. Who has the right to be in charge of the probate? Is it one of his 4 children or the new wife? What do you guys think? Dad is 80 years old. He has 4 children. He just newly got married to a 35-year-old woman. That's right, the new wife. So this is the pyramid that I want this is California law. It's a hierarchy of who can be in charge. So the new wife will be in charge. Now you're saying, oh my God, he's 85 years old. He's only been married to her for 50 days. Shouldn't his children be in charge of his estate? Too bad, so sad. If there's no will, no trust, his new bride, his wife, is going to be in charge. That is the pyramid that's set up by California law. Okay, yeah. And why is this important to you? Who's in charge of the probate? Who has the right to administer the probate? Because whoever has the right to be in charge, whoever's in charge of the probate, whoever is the personal representative of that probate administration, that individual has the power to choose the realtor. Okay, so that's why I'm going to. So if you're best friend with the wife, okay, good for you. You know, she's gonna choose the realtor. You know, if you're best friend with the children, oh, sorry, too bad, so sad, right? All right. Okay. So, so a probate process normally gets started by filing a probate petition. Okay. So here are some vocabulary to remember. Okay. Mom died. You pull up the grand deed. The house is under her name. No, let's just pause here for 1 second. Mom died. The house is under her name. She has no trust. Let me just hammer this home. Mom died. There's no trust. She owns a house. Does anybody want to speak why it needs to go to probate? What mom died, there is no trust. The house under her name. why do we need to go to court? We need to go to court because who is going to sign your listing agreement? Right now, when you take a listing, the seller who's alive signs your listing agreement. But when we talk about probate, the homeowner died, the homeowner is in heaven. Therefore, unless you can go to heaven and find that homeowner in heaven to sign your listing agreement, it's going to have to go through probate. Okay. We need a probate. Okay. And this chart in front of you demonstrates the probate process. We need to go through probate so that the judge can appoint someone to step into mom's shoe, dad's shoe, to sign your listing agreement. Okay. So to be clear, right? To be clear, when you think about it in that sense, that's why you need a probate, because the owner is in heaven. The owner is not available to sign your listing agreement. That's why we go through probate, because there's no trust. In the probate is where the judge will appoint someone to step in to be the personal representative of that estate, whether it's mom's estate, dad's estate, uncle's estate. Okay, that's why. All right. Oh, let's see here. Let's see. So mom passed away. You pull the grandee, the house under her name, it requires a probate. Mom has 4 children. Whichever the 4 who wants to be in charge is, when he or she files the petition, when he or she gets a lawyer, her name is going to appear as the petitioner. She's petitioning the court. Hey, judge, my mom passed away. Mom has 4 children. We're going to sell this house, divide by 4. But judge, you know, I'm the petitioner. Could you please make me the personal representative? Okay. I want you to focus your eye on the screen. Look at the screen. Okay. Here are some important vocabulary. Okay. The person, that son, that daughter, that new wife who is petitioning the court to be in charge, we call that person the petitioner. When he or she has been approved by the court to be in charge, then we call that person the personal representative. Okay. If mom left a will, then we call that person the executor. If mom left no will, then we call that person the administrator. Okay. So this is a very handy flow chart in front of you for you to sort of be able to fit in who's who. Okay. This chart in front of you, remember, only applies when the house is in a probate, when a house has no trust. If the house has a trust, you forget about this chart, because if the house is in a trust, then the successor trustee is the person that's going to be signing your listing agreement. Okay. When the house is going through probate, the personal representative is the individual who's going to sign your listing agreement. Okay. All right. Okay. So, let's see here. Yeah. So let's see. Let's just take a pause here real fast. Let me say hi to Matt. Let me address this question real fast. Let me see if I can click on Matt. Hi, Matt.
Hey, Paul, how are you? Good to hear your voice. Good to see you again.
I am great. Thank you. Yeah, Matt, what is your question?
Okay, so I have a listing that we had listed originally at 2.9, and we went into escrow on the 9th day at 2.75, and it appraised at 2.7. On the 14th day, which happened to be the contingency removal day, our executor for the probate had decided to counteroffer against my strong advice to take the 2.7, which where the buyer was at, and close for the beneficiaries who were preparing to move to Florida. She decided to counteroffer at 2.75 and the buyer walked, which was not a surprise. Since then, the beneficiaries, who happen to be two little, like a 17-year-old boy and a 21-year-old boy, currently now live in Naples, Florida. And I got a price improvement to 2.7, the appraised value. 30 days later, now she's well into her 70s. She just suddenly forgot about it and said, "What the heck are you doing?" I said, "I'm trying to sell your house again, Miss Executor." And she goes, "Increase it to 285. I go, "That would be a major mistake in a falling market." But of course, she's my client, so I did what she said. We went from showings every day to showings like maybe once a week. We just had a showing today, actually. But what the issue is that she's enjoying the pool and spa with her husband in bikinis that are not an attractive thing on Saturdays and Sundays during showings. And then talking to the buyers. I had asked her to, kindly go to the beach or go to the Pacific Club or go to the Balboa Bay Club, as opposed to sitting into a home we're trying to sell on a Saturday or Sunday. Is there any advice you can give me, for a price improvement outside of getting another appraisal done that I'm willing to pay for, and or any advice that I can ask her to essentially do her duty as the executor, because she's clearly failing miserably. We've already sold the house once. She failed.
Okay.
Yeah.
So in every single probate, there's something called an inventory and appraisal. Has that been done yet by the probate referee?
I had asked if that was done by the referee, and the answer was I didn't get a clear answer, and I never got a copy of that. Should I ask the probate attorney if they dig? Now, this was back in May in a different market, by the way.
Oh, okay. All right. So look. So this executor, the beneficiary is a 17 and a 21-year-old. So is this her nieces and nephew?
No, it's the beneficiaries of the grandchildren. There were only 5 family members.
Okay.
The 2 boys got the house. Yeah, the rest got what was left over.
Look, as the personal representative, let me get back to that chart. The personal representative, aka this executor, has a duty to maximize the value of the estate. Okay, so she is the personal representative. She has a duty to all the beneficiaries to sell this house for the most value. Okay, so now conceivably she might be rolling the dice, because what happened if the government increased by another 75-point basis, the market changed, she might be liable because she didn't take her duty seriously.
Correct.
Okay, so I mean, it's you're in a tough spot there. I mean, you kind of don't want to piss her off either, because she's technically your client, but at the same time,
did that already.
Maybe a gentle nudge that says, "Hey, you are in charge, and the court probably gave you full authority, to do the best you can to maximize the estate value. Just let's just hope the market doesn't change and this house sells for $200,000-$300,000 less than what it could have sold for."
Right.
Yeah. And even if you spoke to her attorney, Matt, I think she'll probably say, "Hey, what the heck, why are you talking behind my back?"
That's exactly what she said. Yeah.
Yeah. So it's kind of, hey, let's do our best to sell this house for the most price, and so that, you look, she as the personal representative, her fee is based on the selling price as well. So if the price drop, her fee drop proportionally as well, Matt.
Right.
So you know how we do the 4% of the first 100 grand, 3% of the next 100,000, and 2%?
Yeah.
Whatever price you sell for, we apply that fixed statutory fee. Actually, let me go to that chart. Let me go to that chart.
Sure.
The probate attorney and the personal representative, they get the same fee, okay? And their fee are fixed. I'm gonna find that PowerPoint. Their fee is set up in this manner. It's 4% of the first 100 grand, 3% of the next 100 grand, 2% of the next 800,000, and a 1%. So let's just use math example. Let's just use math example. His let me see here. Let's see let me make this screen real big. So he's selling it for let me just make the math simple. Let's say he's selling for 2.7. The personal representative fee is going to be 4%, 3%, 2%, and 1%. So to calculate the fee, it's going to be 4% of the first 100 grand. It's going to be 3% of the next 100,000. Then it's going to be 2% of the next 800 grand. Then what's left is 1.7. So it's going to be 1% of 1.7. So her fee would be essentially be 40 grand. So as you can see, if she were to sell it for more, she would make more money. If she sell it for less, she makes less money. But also the damages that, hey, you could have sold this for 2.7 and now the market's changed. You're selling for 2.4. Okay.
Right.
Yeah, man, you're in a tough spot, but that is sort of
That's the game.
That's sort of the issue surrounding this I guess having her take this seriously, I guess. Yeah.
Yeah. And I'm letting her know on our checking calls that, you're my highest priority. Getting your home sold again is my highest priority. And I'm trying to dance around and essentially walk on glass with her to get another price improvement.
Yeah.
And then I'm down to what I feel is my plan D at this point, which is just saying, I have 3 appraisers. I'm happy to pay for a current appraisal just so that you understand what the value is. And whatever it comes in at is going to be a good story for us, because we did sell the house already at 2.7. You decided not to move forward, and that was your choice. And now the house is appraising at 2.59. What do you want to do?
Yeah.
I mean, I feel that might be the best approach. Would you agree?
Yeah, just talk to her. Hey, you might not want to wait much longer. If the market change, you might have a bit of explaining to do, Yeah.
Right.
Yeah.
Right.
Yeah.
Okay.
So, all right, Matt, great chatting with you.
Hey, you too, Paul. Hey, it's always great to talk to you.
All right, thanks. Okay.
Appreciate it.
So what I'm gonna put up on the screen is the probate process. Okay, this chart right here, this chart. Probate normally takes 1 year to do. Okay, takes 1 year to do. So the question is, while the probate is happening, because probate takes 1 year to do, are you able to sell this house while the probate is active? The answer is yes, you can sell. So look, if you look at this chart, if you see this little individual with his hand up and there's a bag of money on top of his head, the son or daughter do not get the money or the house until the case is over. Okay, probate takes about 12 months to do. Are you able to sell this house during the probate process? The answer is yes. Okay, so how it works is, if you look at this chart, the probate attorney files the probate process and file the probate petition, publish in the newspaper. About 5 to 6 weeks later, after the filing, he goes to court, get your son, your daughter approved, okay? At the 2-month mark is where letters and orders are issued. 15 days after that, you can close escrow. So a probate with full authority, you're able to close escrow, let's say, probably 85 days after the probate is started, okay? But it has to be a probate with full authority, a probate with full authority, okay? So if you have a probate with full authority, before you can close escrow, escrow is going to ask you for these 3 documents. Let me just show you. Number 1, order for probate, okay? 2, letters. 3, a notice of proposed action. Okay, so you have a probate listing, it's full authority. You can close the probate transaction, the escrow transaction, if you give escrow these 3 documents. 1, order for probate, 2, letters, and 3, the notice of proposed action. And it's 3 simple forms. It looks like this, guys. So the first one is order for probate. It's a form, it looks exactly like this. Remember how I said, if it's a probate with full authority, you just need 3 forms to close out escrow. 3 legal documentation from the lawyer, from the probate court, only 3, okay? 1 is order for probate, looks exactly like that. The second form is known as letters. It looks exactly like that, known as letters. Number 3, the notice of proposed action looks exactly like that. You give these 3 forms to escrow, you're done. You can close that probate real estate transaction. Okay, so keep that in mind, guys. Probate is not that difficult to do. So, for example, when we were talking to Matt, he is at stage number. That executor that has been approved, so orders and letters out. All Matt has to do now is to get that executor, that personal representative, to accept an offer. Once she signs, once that executor signs that accepted offer, then Matt will give it to the probate attorney. He then will go at the lawyer will draft the notice of proposed action, mail it out to all the sons and daughters. 15 days goes by. 15 days goes by, he can close escrow. Okay, so probate is really easy, guys. Just remember, if it's a probate with full authority, you just need 3 forms to close escrow: order for probate, letters, and notice of proposed action. Okay. Okay. So Sean says, where do you get those forms? From the probate attorney. The probate attorney normally will. So Sean, so for example, if it's your listing, and let's say that the son is your client, his mom passed away, you work closely with the son will put you in contact with the probate attorney. The probate attorney in turn will give you these forms, Sean, and you can take these forms, give it to escrow. Escrow will allow you to close this transaction. Okay. All right. So Carl in the chat box, he says, what is the difference in a probate and a conservatorship? Carl is asking me, what is the difference in a probate and a conservatorship? You know, that's a good question. That is a good question. Yeah, let's see if we can say hi to Carl. Let's see if we can say hi to Carl. Let's see here. Hey, Carl, are you able to talk?
Hey, Paul. I might be able to talk for a little bit. I got 2 kids running around here.
Oh, Carl, so great question, okay? So a probate is when someone died with a house and does not have a trust. That's a probate. A conservatorship, Carl, a conservatorship is this. For example, your client, a 75-year-old wife, an 80-year-old husband. These two couples have a house that they want you to sell, Carl. And the husband has dementia, Carl. The husband has dementia. Now, if they don't have a durable power of attorney, Carl, then the wife will go to the probate court and set up a conservatorship so that the judge can appoint her to sign your listing agreement for her husband who is still living but has dementia. That's the difference. Probate is someone died. Conservatorship, that person is still alive but doesn't have the mental capacity to sign anything. Hence, we're in court so that the judge can oversee all the signatures, so that the judge can appoint the wife or the son or the daughter to be the conservator. So that's the difference between probate, someone died, conservatorship, that person is still alive, but is mentally incapacitated, dementia,
Got it.
Alzheimer's, coma. Yeah, that's the difference. Yeah. That's
Thank
a good
you.
question. So Carl, that's why it's important to have a power of attorney. So you need a power of attorney. You can say, if I become incapacitated, if I have a stroke, if I'm unable to think, my wife has the power of attorney to sign for me so that she never has to go to conservatorship to sign on your behalf, Carl. You have a stroke, you have a power of attorney that says, I trust my wife, told her she can sign for me. You have a stroke, you have dementia, she can sign for you. We do not need a conservatorship. Why? Because you have a durable power of attorney.
Great. Thank you.
Okay. And the takeaway is this, Carl. The takeaway is an elderly couple, husband has dementia, wife is fine, the house is too big, they want you to sell their house for them. The wife is fine, she can sign your listing agreement, but the husband has dementia. You ask to see the power of attorney, Carl, where if it points that the wife can sign for the husband, then you're good to go. You can sell that house. Then you don't need a conservatorship.
Okay.
The takeaway is, not only do you need a trust, you also need a power of attorney to avoid conservatorship.
Okay. Thank you.
That's a long answer so that you can fully, kind of
Sure.
appreciate the circumstance, Carl, Yeah.
I might have another question later on. I'll
Sure.
reach out to you privately though. I have to
That's
formulate my question.
All right. Okay.
Thanks,
yeah.
Paul.
Yeah. So Irene Joan asks, does the wife have to prove it to the judge? Let's say hi to Irene. That's a good question, right? That's a good question. Oh, let's see, Irene. Where are you, Irene? Let me say hi to Irene. Oh, let me see. Oh, Irene. Hi, Irene.
Hi,
How are you?
I'm doing well, thank you. How about yourself?
I'm good. So you have a terrific question, right? You're saying, hey, husband and wife, the wife has a power of attorney that she needs to prove something, right? That her husband is incapacitated, right?
Right.
Yeah, because some wife wants to kill the husband or put him in some sort of home, right?
Right.
Okay, so that's a good question. Yeah. So it depends on the power of attorney, Irene. Let's say you've been married to your husband for 50 years. When you did the power of attorney, you totally trust your husband. Your power of attorney is going to say, hey, I trust this. My partner, I've been married to him for 50 years. I trust him totally. So you know what? If I become incapacitated, the power of attorney is immediate. He does not need to take me to see two doctors to deem me incapacitated. Okay. So your power of attorney, Irene, let's say you just got married to this new guy, you know, you're 80 years old, he's 45 years old, your new husband, you're super rich, you have a power of attorney. You might want to say, hey, new husband, 45-year-old, you know, six-pack guy, before you can take over and sign my name, you have to take me to 2 doctors to have them sign off to say I'm incapacitated.
Okay.
Does that make sense?
Yes, yes, it makes sense. So I totally understand. So now let's reverse that. Let's say if there is no power of attorney and they have to petition for the conservatorship, would that have to be proven also?
Yeah, so you and your husband, just use an example, you and your husband and your dear husband is 80 years old, he has dementia, you know, he cannot, I'm just sorry, he really is incapacitated. So you would take him to a doctor, and there's a form that the judge is going to make you have the doctor fill out, that examine him by his primary physician, that says that he's incapacitated. So it's a form, it's called the capacity declaration, signed off by his primary doctor, and you give that form to the judge, Irene.
Okay.
Yeah, good question. It's the conservatorship is heard in the probate court, and the probate judge is going to require a mental capacity declaration from the primary physician, the primary doctor, to sign off that says, yeah, you know, Henry, the husband, is incapacitated. The judge sees that, go, okay, he is, and also the judge will make you give notice to all his children, you know, brother and sister, just before the judge will give you control of your husband 100%, because you have 100% control. You can sell anything, take all his money, commit him to a, you know, mental institution, because there's so much power involved, you know, to be someone's conservator in a conservatorship. There's a bit of have a doctor vouch he's incapacitated. Let's give notice to all his children to make sure that, hey, you're not just trying to pull a fast one over everybody.
Got it. Great. Thank you very much. Appreciate it.
So the moral of the story is, just an example, the moral of the story for all of you out there, okay? If you're in a long-term marriage, it's a 40, 50-year marriage, you have mutual children together, then you can be a lot more lenient on your power of attorney. It says, yeah, I totally trust my husband, I totally trust my wife. But, you know, you're 75 years old and you just got married to this individual. It's only been 6 weeks, 7 weeks. Maybe you should be a little more careful with your power of attorney before you hand over your entire life, right, to this new spouse of yours who you only know for 6, 7 weeks.
Got it.
That's the takeaway from this conversation when you do your power of attorney.
Okay, you answered my question. Thank you so much.
All right, great. Okay, let's see here. Let's move back to our probate. Okay, so look, guys, really easy probate. There's 2 types of authority: full authority, limited authority. If it's full authority, just give escrow these 3 forms. These 3 forms. Form number 1 looks exactly like this on your screen. It's called order for probate. Form number 2, it looks exactly like this. It's called letters. After these 2 forms, if you have an accepted offer, you give it to the probate attorney, who in turn will draft up form number 3, known as the notice of proposed action. You have these 3 forms. 15 days goes by, no one objects, meaning all the sons and daughter okay with selling this property, you close escrow, you're done. That's a probate with full authority. It's that simple. Okay, it is that simple. Okay. If it's a probate with limited authority, you might have heard the term court confirmation, If it's limited authority, if it's limited authority, you're gonna have to go to court for court confirmation, okay? And so for example, if it's limited authority, you have to sell it for at least 90% of what the probate referee valued the house for. It's gotta be a 10% deposit down by the buyer, whereas full authority can be as little as 3%. The buyer has to remove all contingency before you go to a court auction, okay? Before you go to court confirmation, okay? So when you're in a probate listing situation, always ask for full authority, because with full authority, there is no court confirmation. If you happen to be saddled with limited authority, it requires that you go to court to get the judge blessing to sell this house. But before you get to go to court, there's a whole bunch of hurdle that the buyer has to jump through, like AKA put down 10%, AKA remove all contingency, just to go to court. And if another buyer shows up in court, the new buyer can potentially be able to take that house, steal that house, okay? So you don't want that to happen, okay? So that's why I don't do limited authority. Is gonna put a wrinkle into your real estate transaction, okay? You probably don't want that if you're trying to sell it for the highest price at the most efficient manner, okay? All right. Okay. So the decision between limited authority and full authority, it's gonna boil down to your attorney, okay? Your attorney has a big role, whether it's gonna be full authority or limited authority, because the judge is a neutral third person. The judge is just a bus, he doesn't take side between one and the other. He just administers the law. So if your probate attorney drive the judge toward full authority, you're going to get full authority, okay? Have any of you guys been in court and court confirmation and probate to bid for a house? Type in the chat box. Has any of you done that yet? Gone to court in a probate to bid on a house? Yeah. So if you show up in court to bid on a house, okay? So let's say there is an accepted offer. That buyer put down 10%. That buyer clear out contingency. You can show up in court and still steal that house away, still buy that house. You just have to know something called the overbidding process, okay? So let's say, for example, if the accepted offer is 500,000, you're going to show up in court and you're going to start the bidding at 525,500. Do you see that number, 525,500? And that number, the 520, the accepted offer is 500,000. But if you show up in court, the judge is going to start the bidding war at 525,500. Okay. So the formula goes like this: 10% of the first 10,000 is the grand, 5% of the remaining 490 is 24,500. You add up all three numbers, gives you 525,500. So this is the precise formula for overbidding. If you show up at court confirmation and you want to tell your buyer, your investor, what is the starting bid, this is the formula. Okay, this is the formula. Okay. Yeah, so any question on this overbidding process? All right. Oh, let's see here. Let me see if here. Let's see. Yeah, if you have a question, let's see, I thought I saw someone raise their hand. Did someone, Dennis, did you want to ask me a question, Dennis? Dennis, did you raise your hand? No? Okay, all right. Oh, let's see here. If you want to speak,
Hey, Paul, sorry about that. That was another screen here.
sure, hi.
Hey, I have a question. So, in terms of a trust, if you're a married couple and you already have community property with right of survivorship, how does a trust help? Is it only if you're incapacitated and you can't sign documents and whatnot?
Okay, so if you have a house, you should always have a trust. Okay, let's say when your client is buying a house, Dennis, your client is buying a house and they don't have a trust yet.
Mhm.
Your client is buying a house, they don't have a trust yet. Can you see my screen, Dennis?
Yeah, go ahead.
Yeah. Can you see my screen?
Yeah, I can see it.
Yeah. So your client, a married couple, when they go buy a house, and escrow is gonna ask them to choose one of these circle, Dennis. Choose, and because they don't have a trust, they're gonna choose community property right of survivorship because that's the
Correct.
best way. Okay.
Yeah.
And then after that, they can go and create the trust. When they create the trust, it'll go into the trust as community property.
Okay.
So that if the husband died, and when the wife sells the house, there's 100% step up in basis, and the wife will not need to pay any capital gain.
And that only happens when it's in a trust.
Yes. So you and your wife don't have a trust yet. You and your wife go buy a house.
Yes, we have. Okay.
Yeah.
We have a house. It's in community property with right of survivorship.
Okay.
I die. She doesn't get the step up if I die, unless it's in a trust.
No. You still get the step up basis.
Okay.
You do. We put it into a trust, Dennis. What if you and your wife were in a car accident and you both pass away?
Okay.
Then that house is going to go to probate.
Yes.
That's why we put it into the trust. The trust says that if I die, I choose my oldest daughter to be the successor trustee. Hey, if I die, let this house divided by 4. Hey, if I die, I want my oldest daughter to live in there, or all my children live there until they no longer want to live there. The trust controls all that.
Yeah, I have no children, so it'd have to be somebody other than my children. Aunts,
Yeah.
uncles, nieces,
Yeah.
nephews. Okay, so that's the main reason you want to do that, or for power of attorney if I'm in the hospital and somebody has to make a decision.
Yeah, so for you, it's important. So the trust says who gets what. The power of attorney allows your wife to sign on your behalf, sign your name on your behalf. Let's say you and your wife are both in a car accident. The power of attorney would say, who do you trust to sign your check, pay your bill, take care of you both? That's the power.
Okay, got it.
Yeah.
Okay, perfect. Thank you.
Sure. Oh, let's see here. Let's see. Anybody else wants to ask me a question on the mic? Let's see. I see some hand raised. Mo, did you have a question for me, Mo?
Yes, sir.
Hi, Mo.
Hi there. How are you? Thanks
good,
for all
thank
your
you.
great information, Paul. I always come to your meetings and you're awesome.
Oh, thank you.
If I was in a court a while ago and there was a referee there, the appraised referee, I protested and I got accepted to some extent. But how far can we go and how do we do a better job as far as protesting the referee's appraiser?
Okay. All right.
Thank you.
So sure. So every single case has a probate referee. Every single probate case involves a probate referee. And the probate referee is going to value the house. Okay. And so But what people don't understand is that the probate referee who does the valuation, they never go inside the house. They don't go inside the house. They just do a drive-by and comps. So if your house is dilapidated with years and years of deferred maintenance, that value that he puts, that he gives to the judge, is going to be wrong. Okay. So if you to nip it in the bud, to get ahead of that, you would take pictures of all the damages, get a cost of repair, give those to the probate attorney, who in turn will give it to the probate referee, okay, so that he can deduct it from his comp to arrive at a more truer value. Okay? If the house has a lot of damage and repair, because the probate referee, they don't go inside the house. So if they don't go inside the house, they'll never see the damages inside. Mo, does that make sense, Mo? Yeah. So
Yes, it does. Yes, it does. But only question I have is that referee really listen to you and features you give them, or they're gonna argue with you or don't accept what you?
No, they give it to the lawyer, let the lawyer deal with them, because if you show them photographs, videos, and cost of repair, they did not go inside the house. So how the hell are they going to challenge you and say, no, you're lying? Well, you didn't go inside the house. So how would you know, Mr. Probate Referee? You know?
That's correct. That's correct.
Yeah, you know, look, if you don't believe me, Probate Referee.
Let's walk together, right?
Exactly. Let's set an appointment. Let's go see the house. And you know what they're going to tell you, Mo? Oh, no, thank you. I don't have any insurance to step inside the house, blah, blah, blah. Therefore, they're going to take your word for it.
Very good. I appreciate it, Paul.
All right, thanks. Yeah. Okay. Oh, let's see here. Let me sort of continue on with I wanted to cover, okay, are we all done with limited authority? Is anybody unclear with limited authority, court confirmation? Any question on that? Limited authority, court confirmation, probate? Okay. Then I am going to move on to, let me see, what did I, okay, so let me cover, okay, we talked about the fees, okay? So in a probate, the probate attorney, the sons and daughter, gets the money at the very end, okay? But you get your money right away, okay? Do you all remember where this movie came from? This with Tom Cruise. See the picture? Do you remember where this movie came from?
Yeah.
Show me the money. Yeah. So the point is that probate takes a year to do. You can sell this house 90 days after probate start. You get your commission. The buyer gets the house, but the money sits in the estate account. You're done. You got your money. You're done. But the lawyer the son and daughter don't get the money until the case is over. Okay, so that's something to keep in mind. That's something to keep in mind. Yeah. Okay, so the other thing I wanted to talk to you about is your commission. Okay. So your listing agreement is good for 90 days. If it's full authority, it's 6%. If it's full authority, 6%. Limited authority is 5%. Okay, that's your commission. Okay. Let's touch base. Let's touch base on Prop 19 a little bit. So commission, if it's full authority, you can just go 6%, Sean. Because Sean is asking, hey, the commission, does the court determine the commission? If it's full authority, If it's full authority, you can do 6%. If it's limited authority, 5%. Okay, that is the general guideline. Okay, you take a listing, Sean, if it's full authority, 6%. How will you know definitively if a probate case is full authority or limited authority? How do you know for an undisputed fact it is full authority or limited authority? Well, do you remember that the 3 form that I said you needed to close escrow? Remember I said the 3 form you needed? And on one of the form, yeah, so for example, letter has it. If you look at what you see on the screen, is the form called letters, okay? I want you to focus your eye on the second arrow. Do you see the second arrow that's flying in, the second arrow? And there's a check mark by full authority. So letters, it will say that on letters, full authority. Also, the order for probate. Remember I said you needed 3 forms to close your probate transaction with full authority? Order for probate, letters, notice of proposed action. What is full authority and authority is also on order for probate as well. Okay. Focus your eye on my arrow. On the screen, focus your eye on my red arrow flying in. This is red arrow number 1. Okay. So red arrow number 1, red arrow number 2. Oh, wait, let me go to the right here. So even on the order for probate, my 3rd arrow, it's going to have a checkbox by full authority. So these forms will tell you whether your probate is with full authority or limited authority. Okay. So Sandra is asking me, hey, why would anybody choose limited authority? Oh, it's probably due to some, I would say largely inexperienced probate attorney. You know, there might be some other reason out there. Let's say the son or daughter don't trust each other, or maybe the PR, the personal representative doesn't have good credit, but largely because of the attorney, of the probate attorney. Okay, yeah. Yeah. Oh, let's see here. Winston is asking me, don't the estate have to prove that taxes are cleared before escrow can close? The answer is no. The answer, so Winston asked, does the estate have to prove that taxes are cleared before escrow is closed? The answer is no. The personal representative have a duty to file all tax return, pay all tax return. You know, how much is owed on the tax is really a separate issue, whether you can close that escrow or not. The estate does have to pay all its taxes, but that is not a hurdle. That's not a step in order for you to close the probate transaction, Winston. Okay, yeah. Let's cover Proposition 19. Oh, by the way, so when you take a probate listing, you're gonna go with the residential listing agreement, follow that with the probate advisory. So when you take the probate listing, you're gonna use the residential listing agreement along with the probate advisory. And then when you have an accepted offer, you're gonna do it on the California residential purchase agreement along with the probate agreement purchase addendum. Okay, so these are the zip form that you need in your probate transaction. Okay, let's cover one last issue. Let's cover one last issue. Let's cover Proposition 19. Let's cover Proposition 19. One last thing, Proposition 19. All right. Let's do a little contest. Type on the screen if you think, tell me what year you bought your house how much you bought it for and how much it's worth now. So what I'm after is this. I bought my house in 1995 for 250,000. Now it's worth 2 million. I bought my house in 1985 for 100 grand. Now it's worth $1 million. Tell me, so I can demonstrate Proposition 19. Proposition 19 is going after, hey, I bought the house. So Odai bought the house in 1993 for 210. Now it's worth 850. Let's see. So I see Jose got a good deal there for 300. Now it's worth. Okay, let's go with Sandra. Sandra bought this house for 31,000. She in 1971. She found some chump change right in her sofa. She bought this house for in 1971 for 31,000. Now it's worth 1.5 million. Okay. So Sandra, my question for you is this. You bought it for 31 grand. Now it's worth 1.5. Your property tax is probably pretty low. Your property tax right now, Sandra Diaz, is probably pretty low. Sarah Diaz, when you pass away and your children gets this house, is the property tax going to get reassessed? Sarah Diaz, your property tax is pretty low right now. Now it's worth 1.5. When you die, is the property tax going to get reassessed to 1.5 million? Sarah Diaz. So to answer that question, Sarah Diaz, you're going to have to understand Proposition 19. Okay. Proposition 19 says this, Sarah Diaz. Proposition 19 says that house is your primary residence, Sarah Diaz, and your children has to move in. So you live in that house, that's your primary residence, Sarah. And when you die, your children move in, and it's the assessed value plus $1 million. Okay. Okay, so your son lives with you. Great. Your son needs to continue to live with you. Sarah Diaz, what is the assessed value on your house at the moment? When you look at the property tax statement, Sarah, what's the assessed value say? Is it 350? I don't know. What's the number like? The assessed value. You only bought for 31 grand, but property tax has gradually increased. So what is the assessed value right now on your property tax? Take a guess. Probably 350, maybe 250. So you take, let's say, for example, if the assessed value is 250, you take that, you add it to $1 million. So assessed value of 250 plus $1 million is 1.2. The house is worth 1.5. So there'll be tax between the difference. 1.5 minus 1.250, there's a tax. Okay, so that's how you calculate whether your son, your daughter is going to get reassessed on the primary resident. I said primary. Anything that is rental property, kiss it goodbye. Anything that is rental property, property tax will get reassessed. Okay, that's Proposition 19, guys. Okay. The good part about Prop 19, guys, the good part about Prop 19 is if someone is over 55, severely disabled, lost the house in a natural disaster, they're able to sell the house and keep the same property tax. Okay. Yeah. All right, guys. That is sort of what I have, guys. Thank you so much for spending the last 2 hours with me. I appreciate it. I think these are some, you are going to have homeowner who pass away, and once they do, this is the roadmap you follow. Okay. I will send, well, first of all, I want to thank Casey from OCAR for having me on. Thank you so much. OCAR, you're awesome. You're wonderful. They're the one that put this program for you. You are going to have a homeowner who's going to pass away. Okay. when they do pass away, you're talking to son to the daughter, watch this video again. I'm going to give it to OCAR. They're going to post it into their library. I'm also going to email it to you as well. Okay. Give my IT person a couple hours and they'll email it to you. Okay. Yeah. So, all right, guys. Thank you so much for being with me. All of you, your question was awesome. So what I'm going to do is this, I am going to end the recording. And yeah, thank you so much, guys, for joining me.